Module 1, Title IX Training for the Presidents, Title IX Coordinators and Designees, Hearing Panelists, and Advisors. In this module, we'll cover our training objectives, the change in scope of Title IX, the definition of sexual harassment, the scope of the college's educational program and activity, the report and the formal complaint, and conducting an ethical and impartial investigation. Our objectives are to understand the forms of prohibited sexual harassment, become familiar with the stages of the college's grievance process, learn about effective investigative practices, due process protections, and the contents of an investigative report, gain a deeper understanding of important topics such as conflicts of interest, bias, and relevance. The 2020 regulations of Title IX have changed its scope. Now, the colleges must address alleged conduct that falls within the definition of sexual harassment set forth in 34 CFR Part 106 when the college has actual knowledge of the alleged conduct occurred in the United States, and the alleged conduct occurred within the college's education program or activity. Our Title IX policies have also changed. This is an overview of Board Policies 3020 and 5011. As you can see, there are multiple options to address a Title IX complaint. Informal resolution is available in certain circumstances, and the college can facilitate an agreement between the parties to resolve the matter. Or, the college can investigate a matter and resolve it at a hearing to determine responsibility and sanctions if they apply. Part 1, Definitions. Sexual harassment is defined as conduct on the basis of sex, including gender identity and sexual orientation, that satisfies one or more of the following. Quid pro quo harassment is defined as an employee of the college conditioning the provision of an aid, benefit, or service of the college's on an individual's participation in unwelcome sexual conduct. Quid pro quo harassment is based on power differentials. For example, the power differential between a professor and a student, a supervisor and a supervisee, or an administrator and a student. Severe, pervasive, and objectively offensive unwelcome conduct is unwelcome conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the college's education program or activity. Unwelcomeness and objective offense is based on 1. The totality of the circumstances, 2. From the perspective of a reasonable person in the same or similar circumstances. Sexual assault is defined as an offense classified as a forcible or non-forcible sex offense under the Uniform Crime Reporting System of the Federal Bureau of Investigation. Sexual assault includes the following: forcible rape, forcible sodomy, sexual assault with an object, forcible fondling, incest, and statutory rape. Forcible rape is defined as penetration, no matter how slight, of the vagina or anus with any body part or object, or oral penetration by a sex organ of another person without the consent of the complainant. Forcible sodomy is defined as oral or anal sexual intercourse with another person, forcibly and or against that person's will, or not forcibly or against the person's will, in instances where the complainant is incapable of giving consent because of age or because of temporary or permanent mental or physical incapacity. Sexual assault with an object is defined as to use an object or instrument to penetrate, however slightly, the genital or anal opening of the body of another person, forcibly and or against that person's will, or not forcibly or against the person's will in instances where the complainant is incapable of giving consent because of age or because of temporary or permanent mental or physical incapacity. Forcible fondling is the touching of the private body parts of another person, including but not limited to the buttocks, groin, and breasts, for the purpose of sexual gratification, forcibly and or against that person's will, or not forcibly or against the person's will in instances where the complainant is incapable of giving consent because of age or because of temporary or permanent mental or physical incapacity. Incest is defined as non-forcible sexual intercourse between persons who are related to each other within the degrees wherein marriage is prohibited by Nebraska state law. Statutory rape is defined as non-forcible sexual intercourse with a person who is under the statutory age of consent of 16. Dating violence is violence committed by a person who is or has been in a social relationship of a romantic or intimate nature with the complainant. The existence of such a relationship shall be determined based on consideration of the following factors. 1. The length of the relationship. 2. The type of relationship. 3. The frequency of interaction between the persons involved in the relationship. For the purposes of this definition, dating violence includes, but is not limited to, sexual or physical abuse or the threat of such abuse. Dating violence does not include acts covered under the definition of domestic violence. Domestic violence is a felony or misdemeanor crime of violence committed A. by a current or former spouse or intimate partner of the complainant, B. by a person with whom the complainant shares a child in common, C. by a person who is cohabitating with or has cohabitated with the complainant as a spouse or intimate partner, D. by a person similarly situated to a spouse of the complainant under the domestic or family violence laws of Nebraska, E. by any other person against an adult or youth complainant who is protected from that person's acts under the domestic or family violence laws of Nebraska. Stalking is engaging in a course of conduct directed at a specific person that would cause a reasonable person to A. fear for the person's safety or the safety of others, or B. suffer substantial emotional distress. For the purposes of this definition, course of conduct means two or more acts, including but not limited to acts in which the stalker directly, indirectly, or through third parties, by any action, method, device, or means, follows, monitors, observes, surveils, threatens, or communicates to or about a person, or interferes with a person's property. Substantial emotional distress means significant mental suffering or anguish that may but does not necessarily require medical or other professional treatment or counseling. Retaliation is defined as intimidation, threats, coercion, or discrimination against any individual for the purpose of interfering with any right or privilege secured under Title IX or 34 CFR Part 106, or because the individual made a complaint or report, testified, assisted, participated, or refused to participate in an investigation, proceeding, or hearing under this policy. Part 2. The scope of the college's educational program or activity. The college's educational program or activity includes locations, events, or circumstances over which the college exercised substantial control over both the respondent and the context in which the sexual harassment occurred, including any building owned or controlled by a student organization that is officially recognized by the college. Part 3. The report and the formal complaint. While everyone should understand the information presented in the following sections, this part of the module is specifically geared towards Title IX coordinators and designees who serve as investigators. There are many sources for reports of sexual harassment. For example, a concerned third party, such as a friend or a parent, the person who alleges to be the victim of sexual harassment, a report made to a mandatory reporter who informs the Title IX coordinator, a referral from the police department, or the college's care and behavioral intervention team. When a report is received, there are several factors to consider in the college's response. The first is the nature of the report. What reportedly happened, and how did it happen? Things to look for here include weapons, violence, or predatory behavior. The second factor is who is involved. This helps us determine jurisdiction and which policy might apply. The third factor is past history. You might look for a record of past conduct issues or a pre-existing no contact order between the parties. This information provides context that can be valuable in determining the college's response. When you receive a report of sexual harassment, consider who else may need to be notified. If it appears to be a Title IX matter, you should notify United Educators as soon as possible. If, as alleged, it appears to be a Clery crime, remove the personally identifying information of the parties and notify your campus's Clery official. If there is alleged or suspected child abuse or neglect, including sexual assault or abuse of a minor, reporting to either law enforcement or the Department of Health and Human Services is required. Outreach to the alleged victim is critical, and it should be completed promptly. When you connect with the alleged victim, you should offer support and explain the supportive measures that are available to them at the college. For example, perhaps they have missed some classes and need an academic accommodation, or perhaps they need a referral to counseling services that you can provide. Next, listen. Listen to their account of the incident so that you can better understand its nature. And when they have finished sharing, you can explain the next steps and walk through the policy with them so that they understand their options and can make informed decisions. When you offer support to an alleged victim, you might say something like, "The college received a report from a student that you were sexually assaulted last night. I'm reaching out to discuss how the college can support you. Would you like to talk about what happened?" The person may be interested in reporting to law enforcement, but they're a little uncomfortable with the idea. You can offer to help them make the call or to accompany them to the police station if they wish. Another way you can support the alleged victim is to explain the supportive measures that they might find helpful, like referrals to counseling services, options for academic accommodations, or changes to on-campus housing. We've talked a bit about supportive measures, and I believe that their importance cannot be overstated. It can be life-changing for a person to have access to a counselor, for example, after they have experienced something that's traumatic or challenging. And the supportive measures that the college most frequently offers students can include academic accommodations, referral to counseling services, changes to on campus housing or employment, and assistance contacting law enforcement or obtaining medical care. We offer supportive measures regardless of whether or not the person decides to file a formal complaint. We also make them available to the person being accused of sexual harassment. We want to be good listeners when a person is sharing their account of sexual harassment. To do that, we need to think about the context that we're in. If we're currently in a public, crowded area, it's probably best to find somewhere quiet and private if possible. You could let the person know that it's okay to take a break whenever they need to. You should give them your full attention as they share their story. This is an opportunity for you to show up for that person the way you would want someone to show up for you if you were in their position. They may have a complex story, and you may have clarifying questions. It's important to wait and let them finish their account and then ask clarifying questions afterwards. The college has two policies that apply to sexual harassment. Those are Board Policy 3020, which is for students, and Board Policy 5011 for employees. When the person you're speaking with is ready to talk about next steps, you can share that with them the policy that applies and explain the next steps in the process. If for some reason neither policy applies, then you can consider whether another college policy is applicable and then refer the person to the appropriate college official. The next step is to explain the college's policies. These are Board Policy 3020 and 5011, whichever applies. You can help the person understand their options and explain each step of the grievance process so that they can make an informed decision about how to move forward. You may find that a person understands the grievance process but is not comfortable moving forward and filing a formal complaint and instead requests that the college take no action. The college respects an individual's agency and will always strive to honor these kinds of requests. But the person should understand that there are circumstances in which the college is required to address a matter regardless of the person's wishes, because it has to balance that request for no further action with its overall duty to provide a safe, non-discriminatory campus environment. If the person does not want to continue with a formal complaint, you can help them understand that while this may limit the college's ability to fully respond to their concern, the college will offer appropriate resources and services to support them. If the person decides to make a formal complaint with the college, they have a couple of options at this point. They may want the college to investigate their allegation of sexual harassment and resolve it at a hearing, where a hearing panel will determine whether or not the accused person is responsible for engaging in sexual harassment. However, they might not want to go through this complex process, and they might be comfortable resolving the matter informally with the other party. The college can facilitate informal resolutions between parties. This is something we'll talk about more in a later module, and we'll also cover the hearing in more depth. But this is the big picture of the fork in the road. The formal complaint is a new part of our process, and it is the document with the allegation itself of sexual harassment against a respondent with a request that the college investigate the matter. Now, there's two parts to this. The document can be filed by the complainant. They can email it or they can write it in a letter and sign it. However, there are situations where the Title IX coordinator can sign the formal complaint. Those might be when the college receives an anonymous report and so there is no complainant to sign, or when the college has to move forward to address a matter regardless of the person's wishes and the Title IX coordinator signs the formal complaint to start the process. There has to be a formal complaint before a person can access the informal resolution process or the investigation and hearing process. Once a formal complaint is made, the Title IX coordinator or designee needs to assess whether or not it can be addressed as a Title IX matter under either Board Policy 3020 or 5011. There are four requirements, four elements of a Title IX matter. The first is that the conduct alleged in the complaint has to meet the new heightened definition of sexual harassment. Second, the complainant needs to be participating or trying to participate in the college's education program or activity when they made the complaint. Third, the conduct alleged must have happened within the college's education program or activity. And lastly, the alleged conduct must have occurred in the United States. If these four elements are present, the matter can be addressed under Title IX under the appropriate policy. If the formal complaint is missing one of these four required elements, the college must dismiss it under Title IX. That doesn't mean it cannot be addressed by another college policy, but it is no longer a Title IX matter. What we would do in that situation is provide written notice to the parties involved, and they have the right to appeal that dismissal. When we dismiss it, we can again choose to initiate action under another college policy if that's appropriate. There are three circumstances in which the college can choose whether or not to dismiss a formal complaint. The first is when the complainant withdraws their complaint in writing. The second is when the respondent is no longer enrolled or employed by the college. The third is when specific circumstances prevent the college from gathering enough evidence to reach a determination. In these situations, the college would provide the parties with written notice of the permissive dismissal, and the parties have the right to appeal it. Now we're ready to move forward. If the matter can be addressed under Title IX, we would proceed per our policy. If not, we would consider whether another college policy applied, and if so, refer the person to the appropriate official. Supportive measures are always available as appropriate, regardless of the next steps forward. Investigations are designed to be impartial, prompt, and comprehensive. The parties may provide you with their account of the incident, any evidence they have that supports their claim, and the names of any witnesses with whom they think you should speak. The parties also can have an advisor. The advisor could be an attorney, a parent, or a friend. You should encourage parties to obtain an advisor as soon as possible in the process because they will need to have an advisor if the matter goes to a hearing. During this time, a variety of supportive measures continue to be equally available to the parties, and the parties will have equal opportunity to inspect and review all the evidence and provide a written response before the investigation concludes. Investigations consist of multiple stages. Here, we are in the pre-investigation stage. This is where we conduct an ethics check, we send the notice of allegation and investigation to both parties, And we prepare our case file so we are ready to start the investigation. I'll begin with the ethics check. It is important to consider whether your role in the investigation might create any ethical concerns or even the perception of ethical concerns. Some common examples are bias, prejudgment of the facts, and conflict of interest. We'll start with bias. Bias is a human trait resulting from our tendency and need to classify individuals into categories as our brains process information and make sense of the world. This is important here because bias is a ground for an appeal of a determination of responsibility. So, where does our bias come from? That's a complicated question. There are a lot of experiences that can influence a person's bias, including cultural conditioning, media that they're exposed to, personal upbringing, and life experiences. All humans are bound to have bias, but there are two types of bias that we may experience. The first is implicit bias. This is something that we are consciously aware of as individuals. It's an action of supporting or opposing a person or a thing in an unfair way because our personal opinions influence our judgment. The second type is implicit bias. This is the attitudes, stereotypes, things that affect our understanding and our actions and decisions in an unconscious manner. Implicit bias is subconscious. We don't know that we have it. Our investigations need to be impartial, to be fair to both parties. And that means that the investigator must be capable of seeing situations from a neutral perspective and avoiding the influence of bias. I'll start with implicit bias because, in some ways, it is more problematic than explicit bias because we might not recognize that we have an implicit bias. It's subconscious emotions, perceptions, and attitudes. And the interesting thing is that we don't have to actually believe a stereotype for it to cause implicit bias. Mere knowledge of the existence of a stereotype can cause discriminatory actions that we're unaware of. Implicit bias might be something we're not aware of consciously, but that doesn't mean that we can't exercise some control over it. We can go through thought exercises to help reduce it in our minds. The Department of Justice has a community relations service that offers 5 strategies for this: stereotype replacement, individuation, perspective taking, counter stereotypic imaging, and increased opportunities for contact. Stereotype replacement exercises really turn stereotypes inside out. When we do this, we take an automatic stereotypical response and we replace it with a different, new, non stereotypical response. And we do this by acknowledging that our response is stereotypical. We identify it as such, and we think about why it may have happened. Then we think of other responses that we can use to avoid the stereotypical response, and we substitute those in our thinking. Let's say you meet a man who tells you that his child is a math major in college. You reply, "What's his name?" Then the man tells you that it's his daughter who is the math major in college. So let's go through our process of identification, asking why, and creating alternatives. The stereotype here is that males are better at math and are more likely to study it at higher levels. So, why would that response come to mind? It might be because society has very defined gender roles for boys and girls and men and women, and those roles are reinforced through media and marketing our entire lives. So, what could we think instead of the stereotype? We could consider, for example, that research shows no difference in mathematical skill based on gender. We could consider our personal experiences, like a woman we know who is an excellent math teacher. When we can replace the stereotype and change our thinking, we are more likely to avoid stereotypical responses. Another strategy is called individuation. This is giving individuality to people who make up a group. Personalizing individuals within a group helps prevent us from making biased inferences about an individual in that group based on gender or race or sexual orientation. And we can obtain information about the group's individual members rather than making generalizations. For example, the stereotype, women are not interested in science. That stereotypes a group, women. Consider an individual woman who is a scientist. Let's make her career as a scientist more important than her gender in our thinking. Let's learn more about her qualifications, where she went to school, her work experiences, and her accomplishments. This helps us avoid stereotypical thinking. A related strategy is perspective taking. This is when we try to put ourselves in the shoes of a member of a group that is stereotyped, and we take that first person perspective and build empathy from it. So for example, take sex or gender bias. Imagine what it would feel like to lose a job opportunity based on assumptions about your family responsibilities or questions about your ability to be authoritative. Counter stereotypic imaging is a powerful way to change how we think. This is when we think of an opposite image of a stereotype. So, when you think about that, you can think of abstract ideas or specific people, and it challenges the stereotype and it creates a positive association with the counter stereotypical image. For example, stereotypical thinking about sex and gender and employment. A very common stereotype is that women stay home to care for children while men work outside the home. We can address this stereotype by thinking about our female friend who is a doctor and she works while her husband stays home taking care of their child. Our fifth strategy is deliberately increasing opportunity for contact with a stigmatized group. If we create positive interactions for both parties, this helps alter our cognitive processes and the associations we have of a group's representation. So when we think about members of that group later, these personal positive interactions will fuel our reactions and responses rather than impersonal stereotypes fueling our reactions and responses. This really dovetails with previous strategies like individuation and counter stereotypic imaging because it provides an opportunity to learn about a person as an individual and to learn about people who don't conform to stereotypes. One way to do this is to be intentional about communicating with people from communities that are unfamiliar to you. We can learn more and test our own implicit bias through Project Implicit, which offers an implicit bias test. This can help us expand our thinking and our ability to put ourselves in another person's shoes. If you're curious, follow this link to Project Implicit. Another ethical concern to look out for is prejudgment of the facts. This is when we create an opinion about a person or a situation, and we do so before knowing or understanding all of the facts. In a Title IX investigation, this could lead an investigator into making assumptions or being influenced by biases of which they're not aware. It undermines our critical thinking process and the thoroughness of the investigation. Let's look at an example of prejudgment of the facts. Hayden is a Title IX investigator. She reads stories in the newspapers about male student athletes who are found responsible for committing sexual assault. Over time, her mind creates an association between male student athletes and responsibility for sexual assault. Then she begins investigating a young woman's allegation that she was sexually assaulted at a party by a football player. Hayden's not spoken to the football player yet. She has not heard his account of the incident, and she doesn't have any additional information. Her gut feeling is, happens all the time. He probably did it. This informs her interview of the football player and the rest of her investigation. She might not realize it, but she is considering all the evidence she gathers through the lens of, he probably did it. Here, Hayden is not an impartial investigator. Another ethical concern is conflict of interest. Like bias, this is a ground for an appeal. Conflicts of interest can come up during the investigation and also during the hearing in Title IX proceedings. They cover a wide range of circumstances, but generally we can define a conflict of interest as when one's personal interests, perhaps a family interest or a financial interest, could compromise their judgment and how they act. We can all think of examples where we've seen a conflict of interest play out. And sometimes that's because there was a difference between what a person was required to do and what was in their interest, or because someone was not able to check a bias and therefore they were unable to be impartial. We also see this when decisions are made for unfair personal gain. For example, let's consider Darius, a Title IX investigator. He is about to begin an investigation into an allegation of sexual harassment between two employees. The respondent is actually someone that Darius knows. His children and respondent's children play on the same soccer team. They sometimes carpool, and they've gotten to know each other pretty well. And Darius considers this person a friend and is very surprised that they are being accused of sexual harassment. He reads the report and thinks it must be a mistake. There is no way respondent did this. Here, Darius is very likely incapable of neutrality due to his bias in favor of his friend, and another investigator needs to conduct this investigation. Conflicts of interest are not always due to bias. They can also arise when there's the potential for unfair personal gain. Consider Katrina, who is investigating allegations of dating violence. The complainant is an employee of the college, and the respondent is a graduate student. Katrina has not worked very closely with the complainant, but she knows that the complainant will be transitioning into a new role at the college. They will be Katrina's supervisor's new boss next semester. Katrina interacts with her supervisor's current boss frequently due to her role and the office environment, and she thinks, when complainant is my supervisor's boss, I'm probably going to be working with them a lot. I will try to get on complainant's good side now so they like me when we work together. Maybe they could help me get promoted. Katrina has a conflict of interest. She wants to influence the investigation for personal gain. She is not an impartial investigator. In some cases, a conflict of interest doesn't have to actually exist to be a problem. This is because other people may see it as a conflict of interest, even if it's not. For example, Ian is a decision maker in a Title IX hearing. He's reading the investigative report and he thinks that the complainant's name is very familiar. He remembers that the complainant worked as his research assistant for a semester about a year ago. Ian does not know this person very well. The complainant only worked for him a short time and did most of their work remotely, so they did not interact much. Complainant currently works for Ian's colleague, and they sometimes cross paths on campus. But he doesn't really know anything about them as a person. He feels certain he can be impartial in his decision. Should he be a decision maker in this case? I think it depends. If Ian has no bias for or against the complainant, he may be capable of impartiality. But the connection he has to the complainant, albeit a weak one, may make others think he is biased. He should disclose this to the college so that the situation can be evaluated. Now that we've completed our ethics check and we know that we can proceed as the investigator in a case, we need to send the notice of allegation and investigation to both parties. It's mostly important for the respondent because it is written notice of the formal complaint that was made against them, and it notifies them that the college is investigating. The notice is designed to give the respondent the ability to meaningfully respond to the allegations. So it includes details like the date, the time, and the location of the alleged incident, the identities of the people involved, the precise conduct that is alleged to constitute sexual harassment, and the part of the policy that that conduct would violate. There are a few important points that must be included in the notice of allegation and investigation. The first is that the respondent is presumed to be not responsible for the alleged conduct. That presumption continues until the end of the grievance process when a determination is made. Second, the parties need to know that they will have opportunities to inspect and review all the evidence that's gathered, and they can respond in writing if they wish. Evidence that's gathered can include exculpatory evidence, inculpatory evidence, and even evidence upon which the college does not intend to rely in determining responsibility. Third, parties should know they do not have to go through this process alone. Each party is entitled to an advisor of their choice. The advisor could be an attorney, but does not have to be. It could also be a parent or a friend. The advisor will be able to accompany their advisee, the party, to all meetings and proceedings, including a hearing. After this, once the respondent has had time to review the information and they're prepared to meaningfully respond to the allegation, they need to meet with the investigator to be interviewed. This is also an opportunity where we let the respondent know that supportive measures are available to them as well as to the complainant. The third step in the pre-investigation stage is to prepare the case file. The case file helps the investigator organize and keep track of the investigation. It may include a timeline of the incident, a timeline of the investigation, a communications log, a witness list, and a record of delays or unusual circumstances. The beginning of the investigation. When the investigation begins, law enforcement may or may not be involved. Reporting conduct to the college is a separate process from reporting conduct to law enforcement. It's up to the complainant if they report only to the college, or only to law enforcement, or to both. There are circumstances when the college is required to report the matter to law enforcement or the Department of Health and Human Services. For example, the college is required to report allegations of sexual assault or abuse of a minor. Also, timely warnings and emergency notifications per the Clery Act can involve law enforcement. If law enforcement is involved, its investigation might be concurrent with the college's investigation, but it could also occur before the college even received notice of the alleged conduct or any time afterwards. A law enforcement investigation does not obviate the college's responsibility to investigate. However, there may be circumstances where law enforcement requests that the college temporarily delay its investigation. In those cases, the college will work to cooperate with law enforcement. An effective investigation will be strategic and deliberate. The investigator should consider questions like, is this complaint based on a single incident, multiple incidents, or a larger climate? Who do I need to interview? When should I interview each person? Is there a reason that this witness might be biased? What other evidence do I need? What information is undisputed? What information is in dispute? And what does the evidence support? Let's talk about tips for interviewing parties and witnesses. The complainant, the respondent, and any witnesses should be interviewed as soon as reasonably possible because memories fade with time. Memories captured close in time to an incident will likely be more detailed and accurate and therefore more reliable. To conduct an effective interview, the investigator should be able to handle discomfort and keep in mind trauma-informed interviewing practices when speaking with the complainant, the respondent, and any witnesses. You might be asking questions about sensitive and personal matters, and the person you're interviewing might be experiencing emotions like shame, anger, embarrassment, or fear. There are things you can do to make the interviewee feel more comfortable, like having flexibility about where and when the interview occurs, being empathetic and kind and considerate, acknowledging that the interview may be an uncomfortable experience, and letting them know that it's okay to take breaks whenever they need it. I'd like to talk for a minute about trauma-informed interviewing. Anyone who's involved in a Title IX investigation may experience some level of trauma. Trauma is very broadly defined, and it can negatively impact a person's cognitive abilities, like their ability to form memories and remember them chronologically. If you're interviewing someone and they have difficulty recalling an event or explaining it in chronological order, it might be helpful to frame the question differently to focus on the person's sensory experiences. Sense and feel questions can elicit memories of a sensory experience, and that might provide you with helpful information. Some examples of sense and feel questions include: what did you feel when X occurred? What did you hear? What did you smell as X happened? Back to general interviewing tips. When conducting an interview, you should try to let the interviewee speak uninterrupted as much as possible. Because your goal in the first interview, especially, is capturing the person's impressions and recollections. And that might not be conveyed in chronological order, and that's okay. You can ask clarifying questions afterwards and schedule follow-up interviews. At this point, you should also start gathering any evidence the person may be able to provide. Evidence is defined as any kind of information presented with the intent to prove what took place. Formal rules of evidence do not apply in Title IX investigations. Evidence can take many forms, including statements from the parties or witnesses, text messages, social media posts, videos, emails, pictures, security footage, and the like. Evidence gathering starts with interviews. As part of your investigation, you'll interview the complainant, complainant's witnesses, neutral witnesses, the respondent's witnesses, and anybody else who might have relevant information. The statements of these individuals are testimonial evidence. Also, you can request that the interviewees provide you with physical or digital evidence in their possession, such as copies of text messages or social media posts or emails. You can also determine whether the college possesses any evidence, such as security footage or records of smart card access to buildings. The next step is to evaluate the evidence you've gathered. As an investigator, you won't be making credibility determinations or drawing conclusions from the evidence, because that's the hearing panel's job. Rather, you will evaluate and organize the evidence for the investigative report. This involves assessing the credibility of the evidence and pointing out any discrepancies. These are skills that you've used in the past and that will continue to be critical to investigations. A credibility assessment is a way to determine the reliability of a piece of evidence. When evaluating evidence, consider its source, its content, and its inherent plausibility. Also consider whether there is corroboration of that evidence. Corroboration is sufficient independent evidence that supports the fact at issue. Each piece of evidence you gather should be assessed for credibility. It can be helpful to think of credibility as being on a sliding scale. There's information that can add to the credibility of evidence and information that can detract from it. There's also information that is neutral and has no impact. Consider the examples on this chart. Another aspect of the investigation is categorizing evidence. This is a chart that shows all the evidence that will go to the parties for their response and also to their advisors and ultimately to the hearing panel. You can see that evidence that's directly related to the allegations can be relevant, such as inculpatory or exculpatory evidence, or it could be neutral or simply not relevant. The parties will have 10 calendar days to submit a written response if they'd like to do so, and any response will be considered before the investigative report is finalized. The response itself will also be included in the investigative report, so it is on the record. This provides the parties the opportunity to meaningfully respond to the evidence and make any clarifications or additions as needed here. At the end of the 10-day window, you will have completed your investigative report. Now, the relevant evidence that you gathered is included in the investigative report. But there's also likely going to be evidence that is neutral or irrelevant, and that is still going to be provided to the parties. So what you'll do in addition to preparing an investigative report with the relevant evidence is you'll prepare a file that has any other evidence that's directly related to the allegations, but that didn't go in the investigative report because the college does not intend to rely on it to make a determination. Both the investigative report and this file will be provided to the parties and their advisors, and they will have 10 calendar days to review and respond to it before the hearing. Now, the investigator has completed this part of the process. Great job. Module 2 will cover the next steps in the grievance process, the pre-hearing conference, and the role of advisors at this stage. There will be a follow-up workshop for Title IX coordinators and designees that will cover writing investigative reports. Please email tsinclair@nscs.edu to certify that you've completed this module. Thank you very much for your time today. I appreciate it. Please don't hesitate to reach out if you have any questions.